My guest, Professor Osipitan, is a distinguished professor of law and a senior advocate of Nigeria. He's a well-accomplished legal practitioner with a career that has spanned over 4 decades. His expertise spans across general commercial litigation, international arbitration, energy and construction law, insurance law, white-collar crime, election petitions, public law litigation, trial advocacy, and the law of evidence. I began our interview by asking his thoughts on the call made by the Patriots, a non-partisan group of eminent Nigerians led by former Commonwealth Secretary General Emeka Anyaoku, who last week urged President Bola Tinubu to convene a National Constituent Assembly to produce a people's constitution for the country. What are the defects of the present constitution that warrants the call for a Constituent Assembly, a referendum, and a brand new constitution?
Let me start by saluting the high sense of patriotism of the group led by Emeka Anyaoku in terms of the search for people's constitution. I want to say that the constitution itself, which we operate, is not a perfect document because it was crafted by mortals like you and I. And only God can lay claim to perfection. It's not perfect. But I think an amendment of these defective areas will take us to where we are going, as opposed to asking for an entirely new constitution. Areas of concern include the area of devolution of power. That too many powers or too many functions are given to the federal government or to the central government, federal government, under the exclusive legislative list. There's a need to unbundle it in terms of quantity and quality. For example, you're talking about marriages. You're talking about some issues like police. You're talking about different minor issues which should be allowed to be at the state level. So I believe that is what is really causing the problem. The center is too attractive. So there's need to unbundle it. Of course, there are also concerns about revenue allocation in terms of physical federalism. And I believe that those issues can be solved by amending the constitution, as opposed to
calling for a brand new constitution.
Brand new constitution is a very serious business, with profound respect to all concerned. You're talking about you wanting to have elected representative of the people of Nigeria. How do you get that? By voting. But in voting, you find out that people who can vote are people who are 18 years and above. Those below 18 years, are they not Nigerians? Are they not Nigerians?
So you create a whole set of problems.
It's also a theory. Again, what is the assurance that when you vote, you are going to bring out the true representative of Nigerians in an area, in a country where people have perfected rigging of election? So I will caution that it is not possible, legally speaking and factually speaking, for all Nigerians to be represented or to have a say in the constitution. So let us stop all these quest for new constitution. We have a document that is working, and I've always said clearly that our problem is not the constitution. It is about leadership and followership. A good constitution in the hands of bad operators will not lead us anywhere. And a bad constitution in the hand of good operators will lead us to the promised land. So we need to go back to the drawing board and have and cultivate a sense of patriotism. Nigeria today, as a nation, remains an orphan because most Nigerians, will think of themselves first and their immediate family. Nigeria comes last. Let us imbibe a sense of patriotism, and you'll see how well the Constitution as amended will take us there. I like the president's response, that he is more concerned with the welfare of the people, how to grow the economy. When you finish with that one, then you can come back to the constitution. If you have good leadership and good followership, yours truly will all be happy in this country.
Prof, I noted what you said about leadership and followership. The Patriots had also said that the challenges of national unity, insecurity, poverty, and hunger, some of which form the basis for the End Bad Governance protest, are symptoms of the inappropriateness of the constitution that we presently have. But what, for you, are the lessons from that protest, and how can we proceed as a nation going forward?
I think that looking at the protest, you discover that it was something that in Lagos, except for Jota area, I didn't see much of activities because Lagosians have learned their lesson in terms of the NSAS protests. So those who did it in the north, I hope they have also learned their lessons. But the bottom line is that majority of the youth in some places are not educated, and they are also not gainfully employed. That has nothing to do with the constitution. It is about governance. How are the governors governing the states is what we should be asking. You have instances of money paid for work not done. You have roads being rehabilitated twice or thrice on paper, but in reality, nothing is done. Tell me something, is that about the constitution? It's about those people who operate the constitution, and also some civil servants who teach politicians how to siphon money. So as we beam our searchlight on Mr. President, we should also beam our searchlight on our state governors and also on our local government chairmen, and hold them to be more responsible and more accountable, because they are nearer the masses. And whatever is happening at the state level, any aggression at the state level being transferred to the federal is uncalled for.
Since you talked about government that's closer to the people, I want us to go back to that Supreme Court judgment on local government autonomy. There's a relief there that says that monies due to the local government should be paid directly to the local government. And some lawyers have argued that this is at variance with Section 162 of the Constitution. Do you think that the Supreme Court made the right call there, or shouldn't that section of the Constitution have been amended first?
That decision attracted a majority decision and also a dissenting opinion of Abiru JSC. Well, if I have to analyze the provision, then we'll have to call in aid the rules of interpretation of statutes and the Constitution. So bearing in mind that the Constitution is a living document, an enduring document designed to achieve the happiness of the greatest number of Nigerians, if not all Nigerians. There are two rules of interpretation. If you go strictly by Section 162, that money should be given to the state that will now pay it into the joint local government account.
Which some of them have not been doing.
That is a literal interpretation. But then, if you interpret a law in a way, ordinarily that calls for an amendment to achieve the objective. But lawyers and judges are what we call social engineers, in the sense that they use law to solve problems of the society. Supreme Court saw that the federal government, the federal government were in trouble with some governors. So what do? If you apply the literal rule, status quo will remain. So you have the golden rule of interpretation and you have the mischief rule. What was the mischief sought to be achieved by allocating or suppressed by allocating funds to local government? The answer is to ensure that monies are made available to them to develop. And if the money is not made available to them, what then do you do? The mischief rule instructs you to say, well, how do I suppress the mischief of starving them of funds? Give it to them directly. It may not be the best approach, but it's designed to solve a problem that we all see. If you go by the literal rule, that means that those local governments will be starved of funds, and you will have defeated the objective of the Constitution. So, if I may summarize, it's a case of literal rule of interpretation versus mischief rule of interpretation.
With that judgment, does that mean that there's no need to amend the Constitution anymore?
Well, that judgment forms part of the sources of our law. But sometimes the judgment of the court may be a pointer to the fact that there's need for legislative response. I will say that for the avoidance of doubt, the Constitution should be amended along that line to reflect the judgment of the Supreme Court.
Let's talk about the judiciary under the outgoing Chief Justice of Nigeria, Justice Olukayode Orugbola. How well would you say that he has fared? And particularly, let's focus on what more can be done to improve the justice system, in terms of an agenda setting for the incoming CJN.
Looking at Justice Ariwola's scorecard, for the time he has spent there, I would say that he has tried. Yes, mistakes might have been made along the line, but because he is a mortal like you and I, he's not above mistake. But one thing I'd like to give to him is the fact that he's able to hold the courts together, and that for the very first time, you have full complement of the Supreme Court. Since 1999, it did not happen. It happened through him, under his regime. That's not a mean feat. It's something that is commendable. And the effect of it is that we are beginning to see that cases are moving faster. They have 2, sometimes 3 panels sitting at the same time, clearing as much backlog as you have to be, that can be cleared. So in terms of speedy disposal of cases in the Supreme Court, I think that's something commendable on his own part. But again, in terms of the agenda for the for the incoming CJN, yours truly, there will be need to amend the Constitution to ensure that you reduce the number of cases coming to the Supreme Court. This may call for you having state Court of Appeal and state Supreme Courts to take care of those cases that are not going to go to Supreme Court. But there's need for us to look at it very well and ensure that we get it right. Again, I love to see an agenda whereby for the first time in so many years, my colleagues in the academic and some brilliant and forthright senior advocates going straight to the Supreme Court. I can tell you that they will make a difference in terms of enriching the jurisprudence of the cases coming from Supreme Court. Those cases that I read are not too challenging, maybe because of the workload. But I like to plead that give the academics and also the inner bar a chance. One slot. Abiru that is there today, that is sending judgments, and you expect more from him, has a background in the academic. I want to make a promise on behalf of those 2 constituencies that our jurisprudence will be richer if you can just make sure you get them appointed. Again, that also calls for the manner of selection. I would like to plead with this new incoming CJ that as much as possible, we need to resist incursion to the judiciary by the politicians. What I see here now is that you find a lot of politicians, legislators, and also governors trying to push their own people either to the High Court, Court of Appeal, and Supreme Court. People who have no passion for the job, people who don't even have the intellect for the job, are getting there. And when they get there, their decisions are questionable. conflicting, and sometimes not possible to rationalize. So we need to tighten the belt in terms of the appointment of people and the quality of people appointed. Those are the few agenda I'd like to set for Honorable Justice Kekere as she comes in.